The first half of this video is a review of court structure, authority, and jurisdiction, and the second half of the video will cover Learning Objective 1 of this unit, which is the parts of an opinion. In information literacy instruction, we talk a lot about authority, for instance, who bestows authority, and what makes a source authoritative. These issues have become more complex in today's shifting information landscape thanks to social media, multimedia, and instantaneous publishing, among other things. So different information needs require different kinds of resources, which means we have to make judgments about the sources we use. In general, this means that the particular information need determines what kind of authority is necessary, and that different communities of practice may recognize different types of authority. The legal field is one such community of practice. As an expert in the legal field, you should be able to distinguish between two kinds of legal authority and how each applies to different information needs. First, you must be able to make the distinction between primary authority, or the law, and secondary authority, or resources about the law. This unit is devoted to case law research, so we'll focus on the authority of court opinions. Court opinions are a primary source of law. Opinions are the law either because no statute exists to deal with the legal question at hand, or because a court was asked to interpret existing legislation. Landmark decisions establish a significant new legal principle or concept, or they otherwise substantially change the interpretation of existing law. They do this by distinguishing a principle so as not to violate precedent, or by establishing a test that courts can apply in future decisions. Second, you must be able to determine if a resource is mandatory or binding authority, or persuasive authority. Court opinions are primary authority, but they're not always mandatory authority. To determine if a case is mandatory or persuasive authority, you have to determine both the jurisdiction in which the case was decided and the level of court. In the U.S., case law is important because of the concept of stare decisis, or precedent. Courts look to previous courts' interpretations of the law when making decisions. Once a court decides a dispute, other courts should follow the same ruling when presented with the same facts. However, whether or not a court must follow the ruling of another court depends on authority and jurisdiction. Finding an on-point case issued by a higher court in your own jurisdiction is ideal, though it's not always possible. If you are dealing with a legal issue that has not been presented before in your own jurisdiction, for instance, if you're in Arkansas, then you can look to decisions made by courts in other jurisdictions for persuasive authority. Rulings made by courts outside of your jurisdiction are persuasive authority. This means that the court in your jurisdiction does not have to follow what these other courts have done, but you can use this persuasive authority to make your argument stronger. Within a single jurisdiction, the highest court is mandatory authority for all lower courts in the same jurisdiction. A higher court can either affirm or agree with a lower court's decision, or it can overturn the lower court's decision. For example, the United States Supreme Court can overturn a decision of the U.S. Court of Appeals. So you must be able to distinguish between these different types of authority. You should also be aware that the authority of some sources may be weighted differently depending on your situation. So make a habit of evaluating all of your sources for authority. You should also be aware that different legal systems have different constructs of authority. But in the U.S., the opinion of an appellate court becomes case law if that opinion is published and there are no further appeals. So what do we mean by published? It means something specific to say whether an opinion is published or unpublished. Published opinions are those printed in reporters. They should be considered primary authority. A better word for unpublished opinions, though, is non-precedential opinions. Non-precedential opinions are those not designated by the court to be printed in a reporter. Non-precedential opinions at the state level can be found by contacting the court clerk, and you can often find them online. At the federal level, check the federal appendix. For all opinions issued by Arkansas appellate courts or the Arkansas Supreme Court after July 1, 2009, there is no distinction between published and non-precedential opinions. Some opinions published prior to this date may still be considered non-precedential though, but this will be covered in more detail in another video. Non-precedential opinions are not treated as binding precedent, but may be used as persuasive authority depending on the court. You should always consult court rules before citing non-precedential opinions. So when you research case law, you're looking for opinions or decisions of a court. The first objective of this unit is to distinguish the parts of an opinion. So all cases will include some preliminary information. The case name, a citation, and author appear before the text of the opinion. The facts of the case follow this preliminary information. The facts will explain who is involved and what happened. Next is the heart of the opinion. This is where the author explains the precedent and legal principles applied to these facts. Once you've done some research and settled on a case to review, this is the section you'll look at to determine if you can use it to solve your particular research problem. And you will deal primarily with majority opinions. The judge who authors the majority opinion does so on behalf of the other judges who agree with the holding of the court. Sometimes a judge will agree with the ultimate holding of the court but will apply the law in a different way. This justice will write a concurring opinion. When a judge disagrees with the holding of the court, that judge may write a dissenting opinion. Majority opinions will carry more authoritative weight than concurring or dissenting opinions. The National Reporter System is commercially published by West. There are other commercially produced reporters, but these are the most widely known. Commercially produced reporters will include some editorial enhancements, such as synopses and headnotes. We'll cover headnotes later in another video, and you'll have the opportunity to use these in class. The extra information is not authoritative, but it will help you with your research. In the U.S. and similar legal systems, cases are primary authority. Remember that court opinions may not carry the same authoritative weight in other systems. So pay attention to the level of court and jurisdiction to determine if a case is mandatory or persuasive. Whether a case is published or non-precedential will affect the authority of an opinion as well. All published opinions contain the same basic information. Remember that opinions found in commercially published reporters will contain some extra information that will help you conduct research, but you should not rely on this extra information for an in-depth analysis of the case.